A warm welcome to this lesson series on the introduction to the Indian Constitution. In today's lesson, we will have a look at DPSP, Directive Principles of State Policy, as well as fundamental duties, which we find in Part 4 and Part 4A respectively of the Indian Constitution. First, we study the DPSP. The DPSP expands as the Directive Principles of State Policy. You can find these in Part 4 of the Constitution that extends from Article 36 to Article 51. Before going to DPSP, I would like to talk a bit about the fundamental rights. The fundamental rights, as we know, are contained in Part 3 of the Constitution, which is the part immediately preceding Part 4, where we have the DPSP. Now, when we talk of fundamental rights, then who is the beneficiary of fundamental rights? In other words, who is the person who receives the benefit of this? Who is the person who enjoys the fundamental rights? That's quite obvious that it is the citizen of India who enjoys these rights. Now, whenever there is a right that is conferred upon somebody, somebody has to provide it. So now the question is, who is the provider of these rights? Well, the provider of these rights is the state, and therefore, as we saw in our previous lesson, the fundamental rights are available only against the state, which is why Article 12 defines what the state is, and that's why it is so important. Now, when the state is providing the rights, it has a duty to ensure that the right is provided, and therefore the state also has this duty to discharge because there is a right that is being availed by the citizens. This is a very important concept, that wherever there is a right, there will be a duty. These are what are known as jural correlatives, right? Whenever there is a right, you can think about it. You will always find that there is a duty that is cast upon someone else. So, when you talk of the rights of the citizens, then you can see that there is a duty that is cast upon the state. Let me give you an example to illustrate this point. Let us say we talk about Article 14, which we all know talks about the right to equality, which means that the state will have to treat everybody equally. What that means is that the state cannot act arbitrarily, which means it is a restriction on how the state can act. It mandates the state not to do something, right? And therefore, we can say it is a negative obligation of the state because it tells the state not to do something. In other words, the state cannot encroach upon the rights and liberties of an individual. So as you can see, a right, a fundamental right, is a negative obligation of the state. With that background, we will now look at the DPSP, the Directive Principles of State Policy. Now, when I say directive principles, what do you understand? So these are principles that are directive, which means they give a direction. Now, by direction, I do not mean the north, west, east to south. That's not the direction we're talking about. We're talking about the direction which is of the nature of an instruction or of a command, right? Which means that these are instructional principles. And whom is that given to? It is given to the state. So these are the directive principles that determine the policy of the state. Hence, they are called directive principles of state policy because these principles determine the policy of the state. Now, as you can see, these directions are positive obligations upon the state. If you remember, we just saw that fundamental rights were negative obligations upon the state. The reason for that is that the DPSP determine as to what the state should do rather than what it should not do. So these are the instructions to the government on what it should do rather than what it should not do. The fundamental rights, on the other hand, were negative obligations. This is a very important point that you should all understand. So now that we have seen a bit about the DPSP as well as the fundamental rights, let us see as to how they are related, if at all they are. I will talk about the leading case of Keshwananda Bharati versus the state of Kerala. Like I have said earlier, this is perhaps the most important case in constitutional law history. Okay, so what was said here was that the fundamental rights and the directive principles together constitute the conscience of the Constitution. It goes on to say that there is no antithesis between the fundamental rights and directive principles, which means you need not think that there is any kind of conflict between them. On the contrary, they supplement each other. One helps the other. However, there is one very important difference that needs to be known between the DPSP and the fundamental rights. Now, although both of these together constitute the conscience of the Constitution, it is important to know that the fundamental rights are justiciable. What that means is that you have a remedy for these. As you remember, in the previous lesson we saw that you have rights to constitutional remedies. So we saw that in under Article 32, you can approach the Supreme Court directly under its writ jurisdiction to have your fundamental rights enforced. So the meaning of something being justiciable is that you can approach the court to have it enforced. On the other hand, directive principles are not justiciable, or you can say they are non-justiciable, which means that let us say a directive principle is not followed, then you cannot approach the court for its enforcement. So you cannot approach the court. This is a very important difference. So let us say the state fails in securing your fundamental right. You can go to the court. Therefore, it is justiciable. However, if the state fails in fulfilling its directive principles, it is not justiciable. You cannot approach the court for that failure. Let us have a look at part 4, which contains the directive principles of state policy. Bring your attention to Article 37. As you can see here, it says that the provisions contained in this part shall not be enforceable. And therefore, you can see at the very beginning itself that it is not justiciable. Right? It means that you cannot approach the court in order to have these enforced. Let us scroll through part 4 and have a look at what kind of provisions we have. So as you can see, it talks of certain principles of policy that must be followed by the state. Everyone should have adequate means of livelihood. Ownership should be for the common good. And therefore you can see equal pay for equal work for men and women. So you see these are kind of provisions that are very nice, right? It talks about ideals, free legal aid. You can also see provisions relating to just and humane conditions of work, which means that people should be able to work under just and humane conditions, right? So you see this contains very nice ideals that would lead to a very good society. It also talks about the protection of animals, as you can see in 48 and 48A, to take care of animals as well. So therefore, as you can see, this contains ideals, but these are not enforceable. You might perhaps be wondering as to why the DPSP are not justiciable. The reason is that the DPSP are aspirational ideals, which means that they serve as an aspiration, they serve as a goal, or they serve as a target of our vision of what India should be like. However, the present and our reality is very distant from what our targets are. Therefore, to have that enforced by the court would be very difficult. So our reality is very far removed from what our aspirations are. But that doesn't mean that we cannot aspire. It is good to aspire, and therefore we move in that direction. However, to expect that it would be enforced is too much of an expectation. Let us have a look at what the Supreme Court has to say on it. These are lines that are taken from the leading case of Minerva Mills, a very important case of 1980. So Supreme Court here said that the fundamental rights are not an end in themselves, but the means to an end, right? The directive principles of state policy are the end. So you think of fundamental rights as the means to achieve the end, the aspirational ideals, the targets, and those targets are given in the DPSP. So we've studied fundamental rights in part 3 of the Constitution. Then we studied the directive principles of state policy in part 4 of the Constitution. And now we look at fundamental duties in part 5 of the Constitution. Well, no, you do not have the fundamental duties in part 5. You have it in part 4A. So whenever you see something like an A or a B, you should know that it has been introduced through an amendment, right? So whenever there's an introduction of an A, which is a capital and uppercase A, it means that it has been introduced through an amendment later on, which means it was not there in the original constitution. The original constitution is the Constitution of 1949. And if it has come about later, then we can see as to which amendment has introduced that particular provision. Now, talking about fundamental duties, I want to ask you, who is the person who has to perform these fundamental duties? As you must have guessed, it is the citizen who has to perform these duties. Next question. Towards whom does he have to fulfill these duties? Well, it is for the state, it is for his fellow citizens. You also find that he owes duties towards the environment, towards animals, and therefore it is a duty that is owed towards the entire society. So the fundamental duties were inspired by the Constitution of the USSR or Russia, and this was introduced in 1976 by the 42nd Amendment Act, whereby Part 4A was inserted, and there is only one article in that, Article 51A. So the idea of fundamental duties is inspired by the Constitution of Russia. As we'd seen in our first lesson in the series, the Constitution was sourced from various countries, and the idea of fundamental duties is taken from the Constitution of Russia. However, it is important for us to note that the Constitution as of 1949 in its original form did not contain fundamental duties. Fundamental duties came about by the 42nd Amendment Act of 1976, thereby introducing Part 4A. So in 1976, when it was introduced originally, so this does not refer to the original 1949 Constitution. When I say original, it refers to 1976, right? So originally there were 10 fundamental duties stated, which obviously were from 51A to 51A J. And then the 11th one was added through the 86th Amendment Act of 2002. Which obviously becomes 51AK. I will talk about this in a moment, right? So it's important for you to remember that Article 51A is the only article in the entire Part 4A. So now we have a look at the fundamental duties in the Constitution. So as you can see with Article 51, we finish the DPSP, the Directive Principles of State Policy. And immediately thereafter you have Part 4A, and therefore you have Article 51A as the fundamental duties, and then it goes on as 51A, A, B, C, D and so on. So let's have a closer look. As you can see, you can find duties such as abiding by the Constitution, taking care of the national flag, promote harmony, develop scientific temper, preserve the heritage of our composite culture. So as you can see, there are several things that form a part of our fundamental duties. And then going on, you can see the 11th one that was introduced in 2002. Okay, and now I will talk about these for you to understand as to how there is a relationship between the fundamental duties and the fundamental rights. When we talk of fundamental duties, it must be known that citizens who enjoy their rights have to be responsible enough to know that they also have duties to fulfill towards the country. A good example of this lies in Article 21A and Article 51AK. Now, both of these came about as a result of the 86th Amendment Act of 2002. Article 21A lies in Part 3 of the Constitution, which means that it is a fundamental right? And Article 51AK lies in Part 4A, which makes it a fundamental duty. So what is the fundamental right under Article 21A? The fundamental right is the right to education for children between the age of 6 and 14. Okay, so that's the fundamental right. And Article 51AK talks of a duty, and it is the duty of the parent or the guardian to provide for the opportunity for children between the age of 6 to 14 to study, right? So you know that you can, when you talk of education and you talk about the right to education, there also simultaneously arises the duty to ensure that you can give these children the opportunity to educate themselves. Therefore, you will find that fundamental duties always have to be remembered whenever you're enjoying a fundamental right. In fact, you should know that the fundamental rights are not absolute. Fundamental rights are not absolute, and they're all subjected to what are known as reasonable restrictions. So some of the restrictions are given within Part 3 itself, and some others can also be seen by looking at the fundamental duties. The other important point about fundamental duties is that fundamental duties, like the DPSP, are not justiciable, which means maybe, let us say you have a fundamental duty to develop scientific temper, okay, or you have a fundamental duty under 51AK to provide opportunities for children between the age of 6 and 14 to receive education. Suppose you fail to do that. Well, these are non-justiciable. You cannot go to the court because of a failure to fulfill these. So I hope that with this lesson we have got an idea of what the DPSP are and what the fundamental duties are. Thank you so much for your patience. Good day.